Hey, it's Bill Gross, the LA probate expert. And today we're going to fly out of Los Angeles and land in Raleigh, North Carolina, I think it is, right? To interview a attorney in the other side of the country, but I think has some of the same principles will be of value to our California listeners as we expand nationally to help you understand the principles in different states. And so I'm really excited to have here today Ashley Palmer of the Walls Law Group from North Carolina. So Ashley, welcome.
Thank you. And just to let you know, I am not an actual attorney. I am a CPA and I function as a paralegal here at the firm.
I know it's something important, CPA. My son-in-law is a CPA, so I understand the rigor that gets involved in that. So thank you for clarifying.
Sure.
So your role at the Walls Law Group, you're a CPA, and you also work on the cases on the administration of trust. Explain a little bit about what your role is in particular.
So I do estate and trust administration. So I help people when they've lost a loved one here in North Carolina. Anywhere in North Carolina, I help them navigate the probate process at the probate court. I also do provide tax advice as a CPA. We work with other CPA firms for the tax preparation, but so all the forms that go with filling out all the probate forms in North Carolina, I help fill them out under the supervision of the attorneys here and file those with the probate court for people who've lost loved ones here.
Okay, so that's an important distinction. So in addition to the trust administration, you also do probate administration, meaning somebody who files a probate case, your attorney is supervising it, but you kind of walk them through the process where so many people fall down. That's exciting. So let's talk. Well, let's go back a little bit personally, though. How did you end up in working for a law firm as a CPA, and how did you end up in probate and trust administration in particular?
Yeah, so I have what I call my purpose story. So do you want me to share that then?
Sure.
Okay. All right. So let's go back in time. It was Christmas Day, 1985. I was 7, my sister was 4, my mom was 35, my dad was 38. After we opened presents, my mom had to tell us some very sad news. Our father and the love of her life had just passed away early in the morning after a 2-year battle with cancer. And it's a kind that's fortunately now curable. So her bank accounts were frozen. She had never written a check to pay a bill because dad handled that. So the advisors in her life, like the lawyers, CPA, financial advisors, were key in helping her to have the mental wherewithal and resources needed to raise us and send us to college. So a few years out of college, I kind of fell into this job at another great firm. I just knew someone there. I liked it, but I thought it was a dead-end job. And so I was young and upwardly mobile, and I wanted to be CEO at the time. So I quit to go back to school to get my master's in accounting and become a CPA. So I went to the Master's of Accounting program at UNC Chapel Hill. And I did the audit gig for many years, but I always remembered my job at the law firm as the best job I ever had. Wow. It was because I was helping people through a difficult time. And so there was no like helping or making a difference, as an internal auditor. So even though some of my audit clients said they liked to see my smiling face coming, mostly everyone just dreaded seeing us. So about 10 years later, almost to the day, I went back to that same job at the same firm. And I've been doing this work now for the last 9 years. And I absolutely love using my quantitative skills to help people through one of the most difficult times in their life, the loss of a loved one. And so I feel it's my calling and my mission in life to help relieve the burden of the probate paperwork from grieving people.
Wow. And the paper is almost always, in my experience, more cumbersome than people imagine. It sounds great to say, I'm going to do this, and take responsibility for the rest of the family or take over from mom or dad, but it also can be crippling in certain cases. So give us some specifics in North Carolina. I'm sorry, and do you practice only in the state of North Carolina, or are there other states that you practice in as well?
Yeah, so our attorneys are licensed to practice law only in North Carolina. So, and my CPA license is only for North Carolina. So anyone, and our attorneys also do estate planning. So our attorneys and I can help people who have lost a loved one in who's lived in North Carolina or had assets in
Right.
North Carolina,
Right.
or someone who lives in North Carolina if they want to do their estate planning documents.
Got it. So let's talk about first the probate side. Somebody didn't plan ahead, and mom or dad pass, and they're the heirs. What's the cost for a typical probate estate in North Carolina, and what's the typical time frame from when they start the process until they're able to close out the escrow and distribute the funds?
So statistically, most estates are open about 18 months. When the person passed away. My personal record is 5 months. So that's the shortest it's ever been. And we have had some that have gone on for 4+ years. So, it definitely ranges. I think that 1 month to a year and a half, or maybe 2 years, 1 to 2 years, I think is probably very typical.
Hmm.
The cost. So it really depends. I think we can only really speak to at our firm, we can do some analytics on the cases that we have closed to see what, the value is. It's around, I'd say, $7,500 to $10,000. And we find that each phase is approximately $2,500 to $3,000, each phase being like opening the estate, qualification, inventory, and the accounting. And so we have to do multiple accountings. It goes on, and there's obviously, I'm sure the factors that make things take longer.
Right.
In probate. The probate fees are capped. They're $4 per thousand at court, and they're capped at $6,000. Each filing has a minimum of $15 filing fee.
Got it. So it doesn't sound that much less than California, which we have a statutory cap, and say at $1 million, a statutory cap on the attorney's fees is $23,000, and then you
Okay.
could have an executor get paid. That's also capped in the same formula that ends up at $1 million at about $23,000. So if you have $1 million estate, you're going to pay $23,000 up to maybe $46,000 total costs. So that sounds somewhat similar. And then the process when somebody has a probate, is it similar to many states where you have a kind of a two-track process, a full authority and a limited authority, one where the executor administrator have a kind of clearer path to selling property and managing on their own, another one with more court oversight? Do you have those kind of procedures in your state?
What were the things that you said? 30, full 30, what?
Full authority versus limited authority would be the terms in California that we use.
Yes. So I'd say I've got a spreadsheet that has all the different ones. So we have what's called, there's actually 1, 2, 3, 4, 5, 6, 7 different tracks, I'd say. Kind of the most popular, the one that most people think of, is the full probate, and that's, but everything else is a very limited version of that. Some things can be combined as well, but there is a clerk's admin. It can be done if there's less than $5,000 of cash assets. There's a vehicle only. So if it's less than $5,000 vehicle, it can be transferred if all the heirs agree. There's the year's allowance for the spouse and or children, minor children. There's the limited PR, which is really only done in order to run the notice to creditors. And then there's summary administration. That's for spouse. It's available only to spouses, and they have to be the only heir as well. And then there's a small estate. So that is if it's less than, it depends on if there's a spouse or not, $20,000 or $30,000 worth of assets. It can be a small estate. Basically, if it's over $30,000 worth of assets and there's real estate that needs to be sold, we go with the full estate.
Got it. And so on a standard probate, does my sale of property require court approval, or what's the process? I file
Real
for probate, I
property,
get authority, and I have a house to sell. What's the process to get the home sold?
real property.
Mhm.
Okay. So real property in North Carolina vests immediately in the beneficiaries or the heirs. So whether they had a will or not, if they say, I want the property to go to my son and daughter, then the property is automatically the son and daughters, and they don't have to have court approval in order to sell it.
Wow.
Usually what will happen though is, son and daughter, if they want to sell it, they're going to want to sell it rather quickly. So they can sell it, but the notice to creditors ad has to run at least one time. It runs for 4 consecutive weeks. It can run as long as it's run once. If they run the notice today, March 15th, the real estate closing attorney can see that. They can close today or tomorrow. So, and the administrator or executor will also have to join in the sale just to say, we don't need this in order to pay claims of the estate.
Wow.
They have to be really comfortable with that if the notice period hasn't run out yet. In a case where we would have to get court approval, and we are seeing a fair bit of this, young man with a house dies, he's got children as heirs, and so the owners are children, minors, and so they can't, they obviously don't have the wherewithal to have a mortgage and own property. And so he may have committed suicide because he didn't have a lot of money and he was in a lot of debt, and so there's a lot of claims, and so the house needs to be brought back into the estate in order to pay the claims. So in that case, we do have to do a special proceeding at court, have a hearing, say we need to bring the estate back in order to pay claims, and we have to show all that documentation of what the assets are, what the liabilities are, and then we can bring it in and pay the claims. But it's subject to an upset bid process. Do you have something like that?
Sure. We call it court confirmation sale, where somebody can walk into court that day and overbid by 5% plus $500.
Exactly. It's almost exactly like that. It might be 750 and 5%, something like that. So yeah, they have to outbid. So, and the last one that we just did that closed last month was a house that was in extreme disrepair, and so it was outbid 10 times and took 3 months. So this is a great real estate market, obviously.
Yes.
I don't know that it, in a market that isn't so good, I don't know that they've taken that long, because everyone who worked on it, the realtor, the attorney, me, we had never seen something quite like that. So many, upset bids.
And when you say bids, was it one hearing where everybody showed up and overbid, or was it multiple times?
No, it was, okay, I bid, let's say starting bid is 200, and then within the 10-day upset bid period, on the 9th day, somebody upsets that bid, so they submit bids and money at the courthouse.
And it kept doing it every 10 days, or was it just that one day that?
Yeah,
we do it all at once.
We have for 3 months.
Oh, wow. So we have every show up at one time. So I've seen cases where we had 10 or 20 investors show up and bid, and it goes on for maybe an hour. I've seen some wild cases, but so in a standard case, mom and dad pass, I'm a son, I'm the sole heir. You said that the title passes, but there must be a process for that, because the title company is going to want to verify the documents. What's that process look like? I want to sell the house. It's now titled to me. So can I list it right away? Is there something I need to do legally to give me the authority to list the property? And then you mentioned the creditor claim publication. Assuming I do that and have enough time, what do I need in order to effectuate the sale at the end? What kind of documents or processes for that?
So the notice to creditors is really the only thing that needs to be done if the property is to be sold within 2 years. If it's more than 2 years, if you're the son living in the house, you can just keep living there as long as you keep paying the mortgage. And if if you decide 5 years later that you want to sell it, then you can just sell it. The real estate closing attorney title search would just ask, whether you had a will or not, the death certificate of the person. If there is a will, they would want to see it on file. The will has to be on file. No one necessarily has to qualify. If you're going to do it within 2 years, someone has to qualify in order to be able to run the notice.
So I would imagine, in California, we have cases where one son says, "Oh, I have a will," and the other son says, "There was no will," and Dad told me I was going to get the house, and so there's cases obviously of wills being forged or created. It sounds to me like there must be an incentive for that. And how does the state protect the public from that happening? Meaning, again, the scenario: mom and dad passed. Maybe there's two sons, and one waits around for a little bit, and then one day files, says, "I have a will. Here it is. It's scrawled out on a piece of paper." Is the will made public for review? Is there a process where the other brother can challenge the will? How does that happen?
There is a process. So it's called a caveat. Or so if it's a holographic will, then it has to be proved that it is, like, there would probably need to be either a handwriting expert or a hearing with all the family to make sure they agree this is the real will. If it's not, if someone challenges it, then they may choose to do a caveat. And there was another piece to that.
Well, so that's interesting. So does that mean then that a standard sale, when it's inherited, still requires the hearing to verify, to admit the will, and to create the opportunity for challenges of the will to pass? Or
So
again,
I mean, if it's so the holographic wills have to be like proven, if you will.
uh-huh.
But if it's a regular will that an attorney's office has done, and it has two witnesses
Mhm.
and one notary, and it has all the proper verbiage that it has to have to be a valid will,
Mhm.
self-proving, then that it is admitted to probate, and whoever the executor is named, and that's who it is. That doesn't, so like, let's say we have two fighting brothers, one of them is the executor with the will, and he produces it and they say it's a valid will. Once the probate court says it's a valid will, if that brother wants to challenge it, he can do that with a caveat proceeding. If, but that doesn't necessarily, if the property says, the property goes to my two sons, then they can just sell it. They don't really have to do anything besides run the notice, and they would have the will on file, run the notice, provide a death certificate to the closing attorney, and that is enough to prove good title.
And when they sell the property, the proceeds go to the beneficiaries directly, or they stay in the
Yes.
estate?
Yes, and they're not, so it's property technically which can be brought back into the estate if needed to pay claims.
Oh, wow.
But if it's not needed and the executor says, I don't need this in order to pay the claims, then it just goes straight to the beneficiaries.
Wow. So sounds like there's a lot more trust and a lot more flexibility in the system of than California, because California, you would have to get the will not only approved, and before the funds can be distributed at the end of the probate process. You can everything goes smoothly, and at the very end, so we can step in the final accounting and say, hey, you didn't notice properly in the very beginning, and the whole thing kind of reopens again. So it's a different process. So then it sounds to me like there's a tremendous advantage to avoid. There's still a tremendous advantage to avoid the probate process. If you have an estate plan, it's private. There's no probate fees at all. You mentioned up to maybe $7,500 or $2,500 per phase, and the risk of people fighting over things, I think, is also neglected. Talk about that a little bit. How does that work for customers? In California, I would say every homeowner should have an estate plan. It should probably include a living trust. Do you feel the same way? Of course, you can't give legal advice, but as a professional business person, is that your recommendation as well, that virtually anybody who owns property over $300,000 or $400,000 should have a estate plan, and probably that's going to include a living trust?
Well, I do personally think that everyone should have an estate plan, because if you don't have a plan, the state of North Carolina has a plan for you, and you may not like it, right? So, and it obviously, when you have a will, it avoids the bond requirement. But I would say for a trust, so to put, if like I put my house in my trust and then I pass away, it doesn't have to go through probate. The trustee, whoever the successor trustee is, has immediate authority to deal with it. The notice does not have to be run. It's already, funded, the
Right.
trust is funded with the house.
Right.
So it is easier because you don't have to do the notice, and the ad is between 100 and $250 to run that notice. So I would say, I mean, if it's kind of like, I would say if you have properties in multiple jurisdictions, if you have many pieces of real estate, then you have to file the certified copy of the will in the place where you were domiciled, your primary residence. You have to file that in all the other jurisdictions, whether they're in this state or in other states. So
Right.
people who have properties in Pennsylvania and New York and Connecticut and North Carolina, because we had a case like this, it's still open. So it's been several years. Just takes longer,
Right.
to file everything in all of those places to show proper chain of title to sell those assets. So I think if you have multiple properties, it definitely makes sense. If you have highly valuable property, I think it makes more sense, when you have a higher net worth, things just get more complicated. So it streamlines things a lot better to have your property in a trust.
So let's talk about the administration part, because I think so often, people are do-it-yourselfers, and I think with the internet, we've created a culture where you can do anything any professional can. You could sell a house on your own. Well, you can. You're probably going to lose more money than you're going to save, but whatever. You can invest stocks on your own, and there's been whole kinds of scandals with that. And there's also you can create your own trust or will. You can even file your own probates. The challenge I find is not the filing. The challenge I find is the administration, the reports, the accounting in particular. So describe, like, what part of that do you do in the probate process, and what part do you do in the trust administration as far as the accounting and helping prepare the documents that a tax preparer is going to need to file the necessary tax returns?
Mm-hmm. So I do all the accountings for the probate court, annual accounts and final accounts. I also do the trust accountings for our trust administrations. So, would you say what is the process?
Yeah, like for example, on the do you collect all the 1099s and all the various reports that go into a tax return for the decedent and the estate? Is that part of the process that you do? And
Yes. So I would request all that. I would also have all the estate. I would use the estate's bank account statements and the trust bank account statements to generate the accountings. The accountings for the probate court are much more stringent.
yeah,
So everything that goes out has to have a proof. So whether that's the bank statement with a, you know, power bill to Duke Energy on this date for this amount, or a canceled check for same thing. So we have to have the canceled checks or the bank statements to prove everything that went out was proper. But for trust accountings, we don't really have to do that. We just basically list everything that came in, everything that went out, and what we have left. We do that for the estate, but the trust administration is a much more watered down version. You don't have to provide all the proofs. So it's much less laborious and intense than estate ones are. So if, for example, we see a lot, we have clients that have trust and then they miss this one asset, this one stock, and it's $29,000. And they have, a million plus over in their trust that's fully funded, and this one account just, did not get transferred to the name of the trust before the person died. So we have to open up an estate. But they can pay all the legal bills and all the expenses and everything from the trust, and there's plenty of money. So we would encourage them to do that because we write our documents such that the estate and trust can pay for each other. So the trust can pay the estate's bills. So the less transactions you have in the estate, the better, because the less proof you have to provide.
with trust administration, one of the things that I get phone calls for, people need some help where somebody's passed and they have a couple of properties and they sell them, but there has to be an accounting done to the decedent from technically, before they pass, and then there'll be a piece for afterwards when the trust goes on. And it seems that the hardest part of that isn't so much the accounting, it's just getting the authority to get the various documents needed to do the accounting, the 1099s. When somebody passes, the power of attorney is no longer valid, at least in
Right.
California.
That's correct.
And so now you have somebody who passed, who's authorized to get that for the person. Well, you need to have a probate filed to give yourself the authority. Well, I don't need a probate, I have a trust. Well, you need the probate to get the authority from the bank to get the forms to file for tax returns. And it just seems that the banks are so particular in that paperwork, it just really trips people up. Is that part of the process you take on, and what are some tricks you have to make that process more efficient?
Yeah, that definitely is true. So we have an authorization, just a one-page form saying, and we can make it for an estate or a trust or both. It says, I, client name, estate, executor, appointed executor of XYZ estate on this date, this file number in this county, authorize the law firm to get any and all information of all bank statements, all medical records, all claims
Wow.
against the state, all that. And we have it notarized. And so that original notarized document, the original death certificate and the original letters testamentary, if I walk into a bank, I could usually get what I need. I say usually because the bigger banks are more, they're consolidated and they have to send all that information to, a home office in like Kansas or somewhere. And it might take a little while, but smaller regional banks, I can usually get the bank statements that I need.
So you do this daily for a living. This is your job, your business, but you also, I'm sure, have friends and family who aren't in this world. They don't necessarily think in these terms. What advice do you have to them when they look at this? Say, wow, it's a lot of work to get a trust put together, an estate plan. It costs money in advance. I have some assets, but I don't have a lot of extra cash sitting around. What's your best advice to encourage them to take the time to plan ahead to avoid some of the pain and cost down the road?
I can certainly tell a lot of painful stories. So, I mean, and it kind of depends on their situation. If they have a harmonious family situation, then the fact that beneficiaries won't fight if you make a plan or can't fight as much, may not apply. I would say that's fine. You pay us a little bit now, or you pay us a lot later. That's so a little bit now for the estate planning or a lot later to administer the estate. Trust administration, it's just not that cumbersome, right? There's not the oversight. I mean, I'd say trust administration probably costs 20% of what an estate administration would cost. It's just so much less involved generally.
Right.
So I also think if you don't have a plan, you will need it. If you have a plan, then you may not need it, right? So you may not need it for a while. So it makes me feel better to know that I have a plan. If I didn't, that would, cause me a lot of anxiety. The other thing is no one gets out of this life alive, unfortunately. So you're gonna need it at some point. And we also believe that anyone over 18 needs their powers of attorney so that someone else can, deal with your money and your healthcare decisions if you are incapacitated. And so we have a young adult package for that just covers the powers of attorney.
Very nice. Yeah, I like your line, and I say it a little differently than you, that if you don't have a plan, the state of California has a plan for you.
Right.
And you find out the plan by standing in line at the Department of Motor Vehicles. They'll tell you what the plan is. Go to line 1 and wait there for about half an hour, and they'll tell you what the plan looks like. So you may not like the plan, but the state has one as well. So, well, look, Ashley, I really enjoyed our chat. These are some of the details, and I think this is the area that I work in daily. So not the most, I'm sure, I don't think I would insult you say it's not the most exciting topic, except for to those of us who work in this every day, to learn how to help our customers avoid the heartache and troubles and problems. And I'm sure, like you, I see families fighting. I see families wasting resources where just a little bit of planning ahead of time would have solved all of that. And that's really why I do this work. And I think, like
It does
you said
go
at
a
the
long
beginning,
way.
yeah. So I really appreciate that. So if someone want to get a hold of you, what's the best way to reach you to find out more about both you and about the Wells Law Group?
Yeah, you can just go to our website, wellslawnc.com. You can also find us on Facebook. And yeah, but if you go to our website, it has my information on there and the firm's information, wellslawnc.com.
Fantastic. Wells and C, we'll put that in the notes in our social media. And there you have a nice picture of Ashley. If you go down to the second page, and looks like you're wearing the same type of suit and a big smile on it. So I love that picture. When I saw the picture at first, I said, "Oh, this is going to be a fun lady to interview," and it's been a lot of fun. I've really enjoyed it. So thanks for helping. Again, anybody who has either probate or succession issues, or wants to avoid probate, and or wants to talk about trust administration and or trust preparation in the state of North Carolina, Wells Law Group is a large firm with a number of attorneys. Ashley's really just one of the participants, not an attorney, but a CPA who does a trust and probate administration. And we actually have an interview lined up with one of the name partner, I guess, Jason Wells, here in a few weeks as well. So Ashley, thank you so much for your time. Appreciate it. And we look forward to talking to you soon.
Thank you so much.
Okay, bye-bye.